Well, so welcome to another talk in the Simple Speaker Series. We're very glad to have Tim Dornis, professor at Leuphana Law School in Germany. I'd say, Tim, I haven't really known him for very long, I should say, but he came to my knowledge by producing a completely impressive manuscript on a book which now, luckily, we at CUP have been able to...
It's already out.
It's already out. I just got a copy from him. Yeah, do you want to see it? So Tim's got a book out which to some extent covers also maybe some aspects you'll be talking about today. So it's a huge, nice book. I'll hand it over to Jennifer because she definitely have an interest in looking at it. Lionel obviously was also sort of, involved in having a look at it, same as I, and then we were really impressed with your work on that. So we were very happy when you came to ask whether you could present some of this here. And my understanding of this particular issue is very limited, so I'm not going to say very much about it, just to say that I think it plays in the wider ambit about the question of territoriality of IP rights, which we always encounter most of the time still, and of course, whenever we have use which is beyond borders, in particular, of course, in the internet context, we encounter difficulties in addressing, well, the question of territorial rights and how to assess when a particular use occurs within a particular territory and when a state can claim its own laws, its own courts to be able to address that. And Tim is looking at that, I think, in a particular context of US cases on trademark territoriality. So I say no more and hand it over to you, Tim. Thank you very much for coming.
Yeah, thank you very much for inviting me to Cambridge. It's a pleasure and an honor to present the results of a research project I just finished. Let me say something in advance. Now, you nicely introduced that on the basis of the book. You may ask yourself, why American law and why is a German scholar talking on American law, and why is he not even attempting to make it look comparative? Well, the reason is that this is a follow-up project to that larger research project which actually did compare European and American trademark and unfair competition conflicts law or private international law in terms of choice of law, as we say in Europe. And when I was working on the American cases, which are a few hands of cases, I found that they seem to be interconnected somehow, which may not be very surprising to a common law jurist, but for me, who has been trained in a civil law jurisdiction, that is always fascinating again to see how those cases interact and how they somehow work with each other. And so I had the idea that it might be valuable, that it might be a good approach to look at more of those cases, meaning all of the cases that have been decided in the field, not only the few appellate court decisions and the one Supreme Court decision, which is the Steele case, but also the district court cases below. And I thought there might be some value to that. Let me explain what I did. Let me first give a short roadmap on what I'm going to talk about. I will start with an introduction. This would actually be called a literature review, since that is an empirical project. For our purposes, it will be more an overview on the court's doctrine of trademark extraterritoriality, and we can have a short look at the scholarly literature as well. I will then give you a short insight into my method. What did I do? How did I collect those cases? What did I do with those cases? How did I analyze the data I collected? And then I'm going to present you some of the empirical results. I try to limit that to the most important and most interesting parts. I have to admit that for me it's difficult to decide between interesting and uninteresting, because I've been working so much on those cases that I kind of fell in love with the data, and it's difficult to cut something out. But I try. As you see, maybe I failed already. It's a long list, but it's the most important things, as you will see, with respect to the empirical results. And I will close with some conclusions, which are not supposed to say what is right or wrong, rather to invite a discussion on the topics presented. Let us start with the introduction. There have been some cases before the Supreme Court's decision in the Steele case, Steele versus Bulova Watch Company in 1952, cases on international trademark and unfair competition conflicts, but Steele is outstanding. It's the landmark for a number of reasons. It was the first case decided on the, at that time, relatively new Lanham Act, so the federal trademark law in the US, which was enacted in 1947. And it has so far been the only Supreme Court decision on that case. That makes it very important. It kind of is the source of all following decisions. All those decisions that came after Steele are kind of its offspring. That's why I call it the Steele progeny. That is the case population coming after Steele. What happened in the case? The plaintiff was Bulova Watch Company, not only famous for the high quality of its wristwatches, but also for the attractiveness and style of its advertising. They were masters of advertising, were heavily advertising their products throughout the world. They started in Switzerland and they also produced and sold watches in the US. They had a registration in the Federal Register for Bulova. Maybe they had more, but it's mainly about that registration. Defendant Sidney Steele, he came from the watchmaking business. He knew how to do it, and he thought it would be a good idea to produce watches, wristwatches in Mexico. And he thought it might be a particularly good and interesting idea to stamp those watches with the trademark Bulova, even though he was not affiliated with Bulova. And he even managed to get a registration in the Mexican trademark register for Bulova. He bought spare parts, components of those watches abroad in Europe and in the US, but he assembled those watches and he sold those watches in Mexico only. So virtually everything he did after he had stamped those watches with Bulova happened in Mexico. His main customers, however, were Americans on their holidays in Mexico. They bought those watches and brought them back to the United States, where it soon became clear that somebody was copying Bulova watches in Mexico. So the plaintiff started litigation in the District Court of Texas. This went up over the Fifth Circuit, the appellate court, and to the Supreme Court. In the meantime, before the Supreme Court could decide or had to decide, Bulova also managed to get the registration in Mexico cancelled. So there was no more Bulova registration for Sidney Steele. The question the Supreme Court now had to answer was, do we apply American law, the Lanham Act, on that scenario, on what Steele did in Mexico? A strong dissent of that decision said, dissenting opinion said, well, we have a principle of strict territoriality, and since everything happened in Mexico, we cannot apply American law. We may not like what Sidney Steele did, but we cannot extend our law to those facts. The majority thought otherwise. They said, well, we can apply American law, we have to. And they mentioned 3 factors. They did not specify those factors in detail. That's what later courts did. But they mentioned that Sidney Steele was an American national. That made it, in the eyes of the Supreme Court majority, admissible to apply American law. First factor. The second factor was effects on US commerce. They said, well, those watches, those fake watches, they filtered into the US, and that kind of endangered the goodwill Bulova had acquired over the years. Effects could be found. And since the trademark in Mexico had been cancelled, they said, well, we can't see a conflict with foreign law. Would the trademark still have been in the register? Who knows? But they said all those aspects, they point towards application of the Lanham Act. Later courts, I just mentioned why I call it the Steele progeny, those later courts, the children of Steele, they developed in the period between 1952 and 2016. End of 2016 was the time when I made my cut. I have only collected cases until that date. And I found a case population of 159 opinions who more or less dealt with similar facts. Let me give you some more information on the case law. since there was only one Supreme Court decision so far, there is more precedents in the field. And those precedents have been produced by appellate courts. The most famous precedent is the Vanity Fair decision, which has been decided by the Second Circuit in 1952. That decision actually clearly defined three factors, the three factors. They are sometimes called the Bulova factors, sometimes the Vanity Fair factors. Vanity Fair was very strict. They said, well, since in their case there was a Canadian national with a valid registration in Canada, two factors were pointing against the application of American law. And they said, well, that is enough, we can't apply the Lanham Act to what happened in that case. I'm a bit tempted to call the next test an outlier test. The Wells Fargo decision in the Ninth Circuit was decided in 1977. It's often called the Timberlane Rule of Reason because they took the antitrust conflicts rule and applied it more or less modifiedly to international trademark conflicts. The test is, to a certain extent, it's an outlier because it does not use the three-pronged test structure that has been established by Vanity Fair and by Steele somehow. It uses an 8-pronged test. So they test for effects, and then they have a committee test, the rule of reason, with 7 sub-factors, and they balance those factors. Those factors include nationality, conflicts, but also efficiency of enforcement, a comparison of the damages abroad and in the US. There's more precedents. The American rice case, that definitely is an outlier. In the Fifth Circuit, it's interesting because it concerned 2 American rice cooperatives that were producing rice in the United States and selling that rice in Saudi Arabia. And they were fighting over the use of a trademark in Saudi Arabia, on the Saudi Arabian market. And the Fifth Circuit said, well, we find effects here, and I come to that aspect in a few minutes, we find effects here because there is a loss of sales in Saudi Arabia, and that is enough to constitute effects on US commerce. So even though there was no consumer confusion in the States, they said, well, a loss of sales is enough already. And then the most recent precedent case is McBee. It was decided in the First Circuit in 2005, and that is interesting to see. That court went back to an emphasis on nationality. Judge Lynch said, well, nationality is most important if we have an American defendant, an American infringer. We have an easy case of applying our law. It's more complicated if we have a foreign party on the defendant's bench. Yes, that is supposed, I remember, to tell you that Vanity Fair is very important, has grown. Other courts have used Vanity Fair and Wells Fargo as well. Even though it's kind of an outlier, some courts have been inspired by Wells Fargo, and there have been many cases in the Ninth Circuit. Let me come to the scholarly literature just quickly. I may call that the conventional wisdom sometimes because it is conventional in a sense that anybody seems to agree on those issues. There's hardly any diverging opinions here. So first of all, anybody agrees that trademarks can be protected extraterritorially. That is different from copyrights and patents, where the courts say, well, we have a strict territoriality, we can't apply our law to activity outside, or mostly we can't apply it to activities outside the United States. That is different with respect to trademarks, as we can see in the Steele facts and the decision. Virtually anybody agrees on the fact that American courts favor American right owners. They argue that this is important because they may not get the same protection outside the United States in other countries, so American courts have to protect US right owners. Anybody agrees on the fact that since there's only one Supreme Court decision, there's a lack of guidance, it's complicated to apply the law. Some even say the different test variants, the Vanity Fair, American Rice, Wells Fargo, have led to a circuit split, so highly divergent decisions in the different circuits. And finally, there is some discussion on so-called interfactor and intrafactor relations. What does that mean? Interfactor relations means which of the three factors drives the outcome, which is the most important factor. And intra-factor relations means, is there sub-factors to the single factors? Is there certain aspects in nationality or in effects that are particularly important? We come to that in a few minutes. First, I want to explain quickly what I did collecting the cases and working on the data. I started with a Westlaw and LexisNexis database research with the following search strategy. I was looking for trademark with an extension, unfair competition and Lanham Act. And I combined that with extraterritorial with an extender and Bulova. I played a little bit with those factors and those terms, but the lists that came up were always the same, virtually always the same. The search brought 1,500, more than 1,500 cases in Westlaw and more than 1,400 in LexisNexis. I then was checking each single case, whether it was a case of trademark infringement, international trademark infringement, and as could be expected, there was many other cases, international copyright infringements, international antitrust, issues of forum non-convenience, personal jurisdiction. So I excluded those cases that did not deal with the issue of Lanham Act extraterritoriality and international trademark cases. And I ended up with a list of 133 disputes containing 159 opinions. The number of opinions is higher because you may have a district court decision in one case and then a following appellate court decision, and in the appellate court you may have a majority and a dissenting opinion. So you have 3 opinions for one dispute. You had to keep that separate for some of the statistical analysis. The coding means I define certain parameters, variables, which I had to provide a number 0, 1 or 0, 1, 2, 3, 4 when defining what the court said or did. One instance I tested for the nationality of the parties, and I had to say whether it's a US national or a foreigner. Or bad faith of the defendant, and I had to say 0 no, 1 yes. That is the code book where I defined all those variables in order not to get confused myself when coding. That's the Excel list, which is not too long, horizontally, but vertically, or horizontally very long, but not very long vertically, because there were many factors I coded. Most of them, by the way, were not very helpful. There was much information involved that did not give any correlations or any reasonable information, but some did. And I ended analyzing those data or the data in the Excel list with a program called Stata. Now I come to the empirical results. Let me start with the summary statistics. First, with the development of the case law over time. As you can see on the left side, you have the number of opinions in each bin. It started in 1952 with the Steele case, and then you see the 4 precedent cases in the on the appellate level, and you see there was a gap until the 1970s, and then case numbers went up. Overall, the numbers are not too high. I only have a little bit more than 2 cases per year, which is not surprising, considering the fact, it's a very low number, very small number, because compared to domestic trademark cases, at that time you have more than 10,000 domestic trademark cases for the whole time period. So that was much more, but the fact that it's such a small number, it can be explained. First of all, you can't get any infringer in front of court. It's difficult to get them in a US court. And then there has been many years where trademark owners were not very aware of the fact that there is trademark infringement abroad, trademark piracy. There was not much piracy, but awareness that there could be and that there actually is had to grow over time. So the fact that there is not many cases in the 1970s is kind of explainable. Even though the law reviews already said in the 1990s that the cases have exploded or that they would soon explode, a real explosion, if at all, can be found not before 2010. So after 2010, you have 7 cases per year. My expectation is that it may still go up. It looks like it's on the rise. The dashed line is the average number of cases per year. Some more information, more interesting for American statistics, not very unexpectedly, the Second and the Ninth Circuit, those are the circuits, and those are the case numbers. They have the most cases, they handle the most cases. That looks the same in other areas of the law. It's always the Second and the Ninth Circuit. There's some district courts, the Southern District of New York handled 20%, more than 20% of all those cases, a very important court. There's important courts in California, the Central District and the Northern District, they together handle 21 opinions. And then the Seventh Circuit has not much impact here, but still the Northern District of Illinois has decided 9 opinions over time. A short word on the test variants. As I mentioned, the 3-pronged tests are the most dominant test structure used across the United States. So more than 50% of all opinions use the 3 prongs. Vanity Fair is a specific variant of those 3-pronged tests, more than a third. And Wells Fargo, the outlier with the extensive committee test, has been used by approximately a quarter of all cases. That's not supposed to be confusing. Again, we have the circuits down below, and you have the tests up there. I mean, that is 3-prong tests here. The circles here, they indicate whenever a circuit applied one of those tests. So you see a 3-prong test have been applied in virtually most, or in practically most of the circuits. More specifically, you have Vanity Fair applied. I mean, evidently that is the precedent in the Second Circuit. They applied it quite a lot. The same is true for the Ninth Circuit and the Timberlane test on top. But there has been test applications in other circuits. So the First Circuit used to apply the Second Circuit's test for some time, the Third Circuit as well, the Sixth Circuit. And the Fifth Circuit, American Rise, has been mostly applied in the Fifth Circuit. Interesting to see, even though the Fifth Circuit only had 11 opinions overall, and only one precedent case with impact, that impact was strong because the colored, the dots and the X's and the other symbol, they show how the circuits made use of other circuits' precedents. That means anytime a circuit user or a court uses the Fifth Circuit's American Rise test as a precedent, not only referring to it or rejecting it, but using it, mostly for the issue of balancing of the factors. That's why American Rise is important. Then you have a cross. So even though the Fifth Circuit did not produce many cases, it has a huge impact with respect to the ideas it transmits to other circuits.
Can you remind us where the Fifth Circuit is?
Sorry?
Can you remind us where the Fifth Circuit is? Is that Chicago?
That's Texas.
That's
Texas. Yeah, that was the. It started already. The Steele case went through the Fifth Circuit, but it ended with the Supreme Court. So that remained the appellate decision in Steele got completely forgotten. I mean, it's hardly ever cited to. It's a very interesting decision. And the American Rise was 30 years later once more. Yeah.
So just on, the second and the ninth, so as you were saying, this is sort of, I guess one is New York, the other is West. And does it matter what, how you allocate jurisdiction within the states? Is that for trademarks a settled matter in the sense, or is it essentially once you use the mark, well, I mean, yeah, I guess it's really a question whether there is any use in the US, but I mean, is it once, I mean, is there a question of how, which circuit might have?
You need to get venue, you need to get the right venue, that means you either need some effect in the state, which is easy in times of internet advertising and other, and then many of the cases where goods have been delivered somewhere, I assume from reading the cases, could not code for that, but my feeling is that there was a choice between the venues, so you could choose Second Circuit, Ninth Circuit.
So there's some sort of opportunity for intra-US forum shopping.
Yeah.
Okay.
With respect to the empirical results, I want to start with something I have called the extraterritoriality rate. What is extraterritoriality rate? That is the Lanham Act application rate. So I counted how many of those opinions actually applied the Lanham Act, and I divided it by the number of opinions. And you remember I mentioned that there is conventional wisdom in the literature that says, well, US courts, they favor US right owners. That would have us, or expect us, a high number of Lanham Act application, high rate. And actually that's true. The number of cases that applied, or more than 60% of all opinions applied the Lanham Act. But at first sight, that seems to verify conventional wisdom. But there is some theory behind it that is more complicated. It started in the 1980s with the hypotheses of Priest and Klein. They developed a theory of win rate analysis. And the first part of that is highly is uncontested widely. That's the case selection hypothesis. It says, well, among all cases that exist in the universe, most will not reach the court because they get settled. If the parties can kind of expect, if they know before whether it's a winner case or a loser case, it's cheaper to settle than to go to court. It's only the closer cases, the more complicated cases that go to court. The consequence is that we have a very pathological population of cases in the courts. I mean, the impression, as lawyers we know, we have the impression anything can go wrong anytime. But life is less complicated, fortunately. The second part of the hypothesis is more contested. It's the 50% hypothesis, a very simplified. You could say, since it's always the close cases that go to court, it offers many opportunities for a judge to go the one way or the other. And then it's nothing more than tossing a coin which provides you with a 50% chance of winning or losing. It's very simplified. They didn't say it in that way, but it's just to get a feeling of how that should work if you follow that. And actually, that is not only contested, it can't be empirically proven. It's hard to prove that. And there is IP-specific variants of that theory. One has been formulated by William Landis. He says, well, IP owners are very careful when litigating. They fear that they might lose their right, that it might get invalidated, or that its scope might be limited when they litigate too early, or when they litigate bad cases. So that means they only go to court when they have a higher chance of success. And following the theory, the case selection hypothesis, you would then expect a high win rate, because then you bring to court only the good cases, and those are winner cases. You should have more than 50% win rate. The problem for our population is that I read all those cases, there never was an issue of validity of the right. It always was the issue, do we apply American law or not? Many cases were bad faith defendant cases. That means that were clear cases of infringement, piracy, counterfeiting, something like that. So you would not fear losing your right, you simply ask a question, does American law apply or not? And the majority opinion with respect to what IP owners' strategy is the aggressive IP owner paradigm. That's many of our colleagues say, well, IP owners actually try to chill everybody around. They sue for everything. Not only to avoid laches or any defense that might come up if they do not sue, but they also try to frighten possible infringers and to deter possible infringements. That theory actually would lead to a win rate below 50%, because if you carry any case to the court, you may lose more. That doesn't explain our population as well. I have therefore two alternative explanations. One explanation, I have to give credit to Barton Beebe. He has invented that test in an analysis of American fair use opinions. And he explains that a high win rate may be due to the fact that the defendant in a case brings in a weak defense. He throws in whatever he can find to defend, and he throws in also things that are unwarranted, invalid defenses. He just says, well, I have a defense, even though the facts don't tell he or she has. And if that is the case, the idea is that the judge would not spend too many words on the defense in the decision. If that is the case for our population, we would expect the number of words to be low and a correlating higher application rate of American law. Again, you see here the number of opinions in each bin, and that is the percentage of, or the proportion of words spent on extraterritoriality in relation to the number of words of the whole decision. So that means the court spent 5% of words on that issue, 25%, 50%, and almost everything on that. That's what you would expect. There's only a few cases where the court discusses the whole, or uses the whole opinion to discuss extraterritoriality. There's many of those cases where you only have a few words on that. Yeah.
Sorry, with this graph and the previous one, is there a rate that you have for success rates in trademarks generally in the US?
Sorry?
Success rate for trademark litigation generally in the US?
The success rate?
Yes, across all trademark litigation.
So not just extraterritoriality litigation, but any trademark litigation, do you have a success rate?
Success rate for any trademark, oh, I don't have data on that.
Yeah, I just don't.
So we don't know whether the 60%, it could be just that all trademark.
It's a different issue then, but the 60% only concerns do we apply American law or not?
Yes.
Yeah.
And the question, is there success on the substantive law, follows after that. So the issue here is simply, do we extend American law so far? And then after that you would ask, but I would not look at that, I did not look at that. Then maybe those cases said, well, we apply American law, but that there is no claim under American law, which never was the case. I think I remember, because there always was a claim.
Yeah.
Those were clear cases.
Yeah. So I was just trying to
Is
put
that-
it
yeah?
in a little bit more
Sure,
context,
perfect, yeah.
something to grab onto.
So that would kind of suggest, I mean, and this, we didn't really look for that, but it would kind of suggest for those cases, once they had decided in favor of applying US law, most often, because it's, as you were saying, clear piracy cases, you would expect this to be going in favor of the plaintiff, right?
Yeah, so you would, if I can complete that, that is actually the application rate. You see the proportion numbers here. And that says, well, if there is only little discussion in the decision on extraterritoriality, the LL.M Act application rate is only a little bit higher than if there is much discussion.
Yeah.
So it's not very steep,
Yeah.
which you would expect if there is a big defense phenomenon or a big defense paradigm in those cases. So that does not really explain why we have such a high win rate. There may be cases where the court did not spend much discussion on the issue, but nonetheless, the application rate for the LL.M Act was not much higher than in cases where the court was discussing a lot.
So can I just clarify again? When you say win rate, you just mean
On the
application on the
exactly,
single issue.
only on that issue. Yeah.
And the win rate then for the cases after that, are you going to get to that or?
That could be different, but my feeling is I did not code for that, because sometimes the court just sent the case back to the district, or just said I give the case back to the parties and they now have to tell me on the substantive law. I did not know whether the case ended as a winner case or as a loser case in total. I just knew how the issue of extraterritoriality was decided. So that is, and that only concerns the issue of extraterritoriality.
Okay. But I'm still a bit puzzled by this, because so imagine you had a succession of 5 cases in a single circuit. You would imagine the first case, they discuss quite a lot what the rules on extraterritoriality will be. But by the time they get to the 5th, they don't. They say, we're just going to apply the 3 factors from Boulevard.
Exactly.
So this is exactly what you would expect. In the first cases, a lot of discussion and the results. And then in the later cases, that's
In the first cases you say they do all the work, and the others, that's what I have to say from reading the cases and from coding it. The restatement of the former case law always took 2 sentences.
Yeah.
And that was not much free writing for the later courts. The most they had to do was applying those tests to the facts. That was kind of burdensome sometimes, because in particular the effects There's cases where you have discussion of effects over pages and pages.
Yeah.
And I guess it also means that the facts, well, this is over a long period of time, so that may mean, I mean, just the advent of the internet, for example, might just change quite significantly how you apply the factors to the facts. Right?
Exactly. So I have not coded for that. I have in the backup sheets, I have a picture on the internet, and again, there's actually you can't show a correlation. Just to mention that, but I have something for that later on. But it seems, at first sight, it seems as if the landmark application rate went up with the internet. But that was complicated to show because there were not enough cases to give a solid analysis.
I don't know whether I should leave this to the end, but this is just the question that comes from what everyone else is saying. You didn't look to see the overall success rate of the cases.
No.
Could not the idea that you would decide that yes, extraterritoriality applies be based on the fact that you think the plaintiff has an incredibly strong case? Whereas when the plaintiff has a very weak case, you might say, why bother? You know, we'll just say it doesn't apply.
Exactly. Yeah, that's a good idea. I have taken care of that with respect to bad faith scenarios. Mm-hmm. So whenever there was a clear case of piracy, you could show that courts tended to apply the law, which they never clearly said, by the way.
And I wouldn't expect them to say
yeah.
it would be something.
It's a hidden factor.
Yes, that's what I would have thought. Yeah.
And then there might be another aspect, but that's complicated to code for. Many cases don't give that information. If that is a weak case anyway, you may not spend much discussion on issues up front. You might probably jump to the weakness of the case.
Yeah.
But then often the courts did not tell us about the substantive law.
Yeah.
They just say, well, that's the issue of extraterritoriality, so we deny it here, and that's the end of the case.
Sure.
Because then they don't apply foreign law. I should have mentioned that. They don't follow that Savinian system or that European structured system of multilateral choice of law. They either apply their law or they reject it.
Just on that point, maybe an interesting comparison in a way, because if you look at the changes in EU trademark law, expansion of substantive trademark protection to goods in transit, well, the kind of cases you want to capture there is exactly your kind of piracy, bad faith kind of thing. That's where you don't really care whether there should be better, Peruvian, whatever law. You want to get the bad guys, but if you can, if the goods are physically in transit in the EU, then you want to get them.
So I've got two more questions about this. One is why you went for proportion of words, and the second is, in cases of simple piracy abroad, I'm surprised that the proportion of words isn't 100%, because the only issue would be extraterritorial application. So it's weird to me that you haven't got any that are right up.
Yeah. So the proportion of words, I have to admit, I found that several times, but the most sophisticated way to do it was Barton Beebe, who has that hypothesis or that assumption that the proportion of words reflects the strength of the defense. And I kind of agree because
it just depends what the other issues are in the case.
Yeah, and then there were many issues. Even if it's a clear case of piracy, we will see that in a few minutes. You need personal jurisdiction on that. Then you have maybe a foreign non-convenience, or you have a service of process problem, and then there was more discussion on that.
Okay, so you've got other private international law issues.
I admit that this is that's kind of a diluted data I'm presenting, but there is at least you can have a rather weak conclusion that there is no significant or no strong effect of weak defenses here. I mean, there is a bit, but it's not too much. A second attempt, and that's my own idea, to explain the higher Lanham Act application rate, you could call that the preselection by personal jurisdiction extraterritoriality concurrence. Let me explain what that means. If you are suing for relief as a US trademark owner, and you have a foreign party or a national party, you have to establish subject matter jurisdiction. That means you show you have an American trademark to open the scope of the Lanham Act in the first place. Then you have to explain whether it extends extraterritorially. That used to be the same issue as subject matter jurisdiction, but recently courts have separated those two questions. So then you test for extraterritoriality according to the three-pronged test or the Wells Fargo test. But then in addition you need personal jurisdiction over the defendant. That can be based on domicile, presence in the United States, minimum contacts under long-arm statutes or other effects, and it includes service of process. And let me show you a bit of graphics on that. If you assume there is a lawsuit in the United States, it may be easy to get, I'm calling those competitors for a certain reason. We will see that towards the end of the presentation. You get all those into a US court because you have jurisdiction, personal jurisdiction on the basis of their being domiciled or being a resident of the United States. You may get some of the foreigners as well if they direct their activities towards the US. You have then minimum contacts or whatever. But many of those that produce counterfeit products, for instance, you won't get because they may sell those products to somebody else. They may not direct their activities to the United States. And even if they do, you may not be able to serve them with process. If we look at that, we would expect the number of defendants or the composition of the defendants bench in those cases to be more or consist more of American parties than of foreigners. And actually, if you look at the data, you see that only 17% have been defendants with foreign nationality, foreign companies or foreign individuals. The rest of the cases consisted of either American parties only or a combination of American parties and foreign parties, usually an American company and a foreign national owning the company. And in 14% of the cases, you see that on top, the courts were not clear about the nationality of the parties. So they were kind of giving John Doe number 1 to 51, and then it was unclear what nationality those defendants had. So you have a majority of Americans on the defendants' bench, mostly Americans that are defendants in those cases. So personal jurisdiction is more likely to exist with respect to domestic parties. And the consequence is that the Lanham Act is also more likely to extend extraterritorially. Remember the three test factors. Nationality exists already in most cases. So that already points toward application of American law if you have a US party being a defendant. And some of the effects factors, the sub-factors that are used to find effects, may also be triggered already if you have a national party. One of the sub-factors, for instance, is making use of American infrastructure. If you have American bank accounts or you use the American mail, that may suffice already. So if you act in the US, there may not be effects on the market, but you just use that infrastructure. That also somehow bends the test toward application of American law. Overall, if we have a large number of domestic defendants and a higher probability of Lanham Act application, we would expect an overall higher Lanham Act application. And that actually is verified by the data. US defendants had an application rate of 65%. So whenever an American defendant was on the bench, you have 65% of US law application. If it was a combination of an American company, for instance, and a foreigner, you have more than 60%. And then if you had foreign defendants only, it was only 32%. And that result was statistically significant, the last one. So that was not by happenstance, that was really a characteristic of the population. So in combination, the weak defense argument, maybe to a lesser extent, but to a stronger extent, the combination of a majority of US domestic parties and a tendency to apply the Lanham Act to those parties may explain for the higher than average Lanham Act application rate.
Can I just ask on the foreign defendants?
Yeah.
I would assume, for example, that findings of effect would be much more easier to be shown if you had a Canadian or a Mexican. Yeah. Would that be in fact supported by the data? Did you distinguish between like a Saudi Arabian on the internet, or?
That's a very good question. I have to admit, I have not coded for it. But my feeling would say yes, it's easier to get American law applied if there is something going on between the US and Canada and between the US and Mexico. Yeah. There is some cases. There was a Trader Joe case, famous case, most recent case, where somebody bought Trader Joe products in the US and brought them to Canada and sold them there. So and
the Steele case itself,
exactly.
Right?
That's
kind of shows
exactly.
like you do something in Mexico essentially because you still want to cater the American market, right? It's the American tourists coming to Mexico to whom you essentially sell your product.
Yeah, that's a good argument. I mean, I could try whether the data gives more information on that. That would be. I coded for the area where something happened. I didn't include that here. It showed that there is 1/3 Europe and North America, 1/3 many jurisdictions and 1/3 Asian jurisdictions involved in those litigation.
Based on this data, I assume practitioners wouldn't have these precise values, but they probably have a good feeling from the case law. Do you see foreign defendants arising less in the case law because the trademark owners know that they're less likely to be successful on this point?
You think that the attorneys counsel their clients and say, well, that's a foreigner, don't go to court? Could be.
And you probably see if you put an N value in and then looked at it over time, I guess, because I think you said early on that the nationality of the defendants was one of the most important elements in determining whether they could apply to that.
Yeah, well, it's interesting. I mean, the question is, my impression is that they try to get anybody they could get.
Okay.
But that's simply the impression from reading the cases. I don't.
And it goes to the idea of having the strong basis of the case.
Yeah. The point is, you would need more qualitative analysis here. You would have to ask the attorneys in the law firms.
You'd also want to know to what extent, so by country, to what extent it's easy for US companies to sue foreign defendants based on the foreign law in those countries.
In those countries. I have some data on that as well. Yeah. I have not included that, but I have some correlations which kind of puzzle me, and that's the reason why I have not included it. Yeah. One more thing to the Lanham Act application rate. If you look at the variation, conventional wisdom says, I mean, scholarly articles say, the Second Circuit's rate is below the Ninth Circuit because the Ninth Circuit is a balancing approach and that opens more opportunities to apply American law. So the judge has more discretion to do it. Other circuits are widely unexplored. If you look at the overall numbers, that is true. The Second Circuit has an application rate below 50%, so they don't apply the Lanham Act that often. The Ninth Circuit is above 60%, and the Fifth Circuit is at 92%.
That's the one with the odd one.
American rights, exactly.
American rights.
Yeah.
And there was the effect simply of, the Saudi Arabian market fight,
Exactly.
simply because that it impacted on the income
Exactly.
of the
On the sales.
company
Yeah.
in the US that would sufficiently be triggering an effect.
Yeah, exactly. I have more on that. And then those data is interesting to see in a temporal perspective, because then it's more nuanced. If you look at the blue line is the average, the overall average at 60%. Here you see that is 60%. That's the time frame 1995, 2000. The red dashed line is the Lanham Act application rate of the Ninth Circuit. And then conventional wisdom, which started in the 1990s, is right that it has a higher application rate. It's more favorable for US right owners. But you see, it started going down. That high watermark ended in 2000, and it has ever since declined. And the green line is the Second Circuit, which, as conventional wisdom says, has always been below a little bit. But in 2005, it was higher than the average. And then it went down again significantly. And the dotted line is the other circuits combined, other decisions.
And you said you had about roughly how many cases per year?
7 per year towards the end.
Yeah.
So the data is very smooth the statistical program offers a smoothing factor, so that would be less convenient to look at if there is no smoothing in. So that kind of distorts the picture a little bit. But you can see in the end, the extraterritoriality rate in all circuits somehow ended up somewhere near the mean, the average.
Does it depend on individual judges coming in going?
Yeah, you mean that depending on the person of the judge? Yeah, I coded for the name of the judges, but I have to admit, I did not look at the data in detail because I realized there was one judge who decided 3 cases, and there was no, I mean, it's always a different judge. It was Judge Jin, I think, in the Second Circuit who decided 3 cases.
Isn't that the guy who decided Google?
Google Books.
Yes. So did he? Do you remember? Did he?
I can tell you. Yeah. But there was no. That would be interesting to look at that in 100 years from now, and then maybe. But then you still don't have enough judge personal cases because there's so little cases each year. And then I have a very provocative hypothesis here, and I say it's provocative, and I'm very careful. I can't say what was the reason, but if you look at that numbers that I now present, you could say whether, or you could ask yourself whether that conventional wisdom that the Ninth Circuit is the better circuit for right owners kind of induced kind of forum shopping, as you mentioned it, Henning, just a few minutes ago. Because in the 1980s already, the law review article said go to the Ninth Circuit, that is the better test for right owners. What could be the consequences? If you look at the proportion of newly filed cases, again, that's the time frame. Then you see the blue line is the Second Circuit. In 1980, 20% of all cases, newly filed cases, were filed in the Second Circuit. It went up to almost 40% toward the end of the 1990s, and then it went down. And if you now look at the red line, that is the Ninth Circuit. The proportions were pretty low around the end of the 1990s, and ever since they have gone up. And in 2007, the Ninth Circuit actually overtook the Second Circuit with respect to the number of cases that were filed in the Ninth Circuit. I don't know whether attorneys read those law review articles and then decide to go to the Ninth Circuit. But I spoke to a friend he's a patent practitioner, and I was so excited about those results, and I spoke to him on the phone, and I said, well, what do you think? And he said, well, I don't think, I just think about liability. If I don't go to the Ninth Circuit and I lose the case, then probably the client will come and say, well, I found out that the Second Circuit is not the best place to go, why didn't you tell me? So there could actually be some effect of the conventional wisdom telling people that the Ninth Circuit is the better place to sue that kind of induced a certain aspect of forum shopping.
So was the Ninth Circuit the one which had this multi-factor?
Exactly, yeah. That's the Timberlake.
That you said would also in itself be something which would lend more towards the application of a
Exactly, yeah.
Right. But why? I mean, it seems essentially like, these, at some point, obviously the Second Circuit was much more, and it seems to be having a substituting effect, right?
Yeah, seems to.
So at some point people must have thought Second Circuit is either the better place to go,
Yeah.
or if they had the free choice. If
Yeah.
there was,
It seems to be, and looking at the case numbers in the second picture we had, that shows that the Second and the Ninth Circuit handle the bulk of cases, you would say whatever gets lost in the Second probably has to go to the Ninth.
but you can't relitigate, right? You can't sort of, first have the main,
Change the venue or something? No.
So it's, once it's decided,
I guess,
you can't
yeah.
really, I mean,
So this period when people are litigating in the Second Circuit until 2005, primarily they're litigating in the Second Circuit. At that point, the Second Circuit has from your previous slide, had a low percentage.
They always had a lower percentage.
Yeah. But then, at that point, 2005, which is the second? Green. Oh, it goes back down to green.
Yeah.
But it goes up a bit.
The problem is those data were not known to the. I mean, the only thing people knew was what law review articles had written on that.
Yeah.
Or they could look at the case law, but the case law I mean, I'm not sure about or whether American law firms look so intensively to all the cases. Maybe they do. Maybe they collect all the cases and then they make their own statistical.
I mean, what I was thinking is that this pattern roughly shows, doesn't quite show, that the increase due to forum shopping means that the success rate goes down.
There could be a correlation as well. Yeah.
Yeah.
I mean, that's what I thought about. And I spoke to, I mentioned the practitioner I spoke to, because if you apply the case selection theorem, Priest-Klein, you could say, well, I mean, if there is more cases being brought to the Ninth Circuit, there may be more loser cases coming to the Ninth Circuit, and so the success rate is going down. Yeah, that could be. I have not included that here, and because the question is, I mean, you can't show how the quality of the case was difficult. I mean, even reading the cases is difficult. Yeah. Interfactor analysis. That is the question: which factor drives the outcome? Which is the most important factor? And I just want to give a short overview on what you can call the Bulova rhetoric. That is, what do courts and scholarly commentaries say about the factors? And Vanity Fair, as I mentioned before, was a very strict test. They said, well, absence of one factor might be determinative. That means we don't apply American law if one factor points in the other direction. And two factors absence is certainly fatal. That was diluted by Wells Fargo, the multi-prong committee test that says absence of one factor is not necessarily determinative. We rather balance those factors in a rule of reason. And then you have some courts and law review articles that say, well, if we don't have effects, we don't apply. That's an iron rule. And if we have effects, we do apply. But only a few who say that with such clarity. What is the data? Let me again go back to the word count per factor, just to illustrate how those factors developed with respect to what the courts invested in arguments. I don't know whether you can see, that's the green line is the nationality factor. It's very low. So it has less than 10% of the overall words in the decision allocated to it.
Would that include discussions of residence as well?
Because otherwise one would say, well, you don't really have to spend much.
Exactly. It's either an American.
You either are American or you're not. Residence maybe is
There's something,
more complicated.
one intra-factor aspect I did not include in the presentation. It's called constructive citizenship. So the courts have developed a doctrine which says whenever somebody is the kind of the governing force behind a U.S. company, we don't look at a foreign nationality, we consider that person a constructive citizen. Or if some company has a subsidiary in the United States. So that kind of occupies a bit of space in the decision. But still it's a very weak factor looking at that. In particularly if you compare it to the effects factor. There's much more discussion of effects, and you see it's even going up over time. Most interesting here is the conflict factor. It started pretty strong, and ever since the 1990s, it seems to have lost. It even lost against the nationality factor.
Can I ask a quick question? Are you saying, therefore, that the nationality factor is not important in deciding these cases? Or is it that it's crucial in deciding them? And so you don't spend much time talking about it because if it isn't there, you're not going to bother with the other two.
They're not really discussing it. I mean, the point is, I come to the actual effects of nationality in the next slide, but it looks like, at least with respect to the effort they invest when they write those cases, the decisions, the nationality factor is treated a bit stepmotherly.
Yeah, so what I'm saying is, because I can't understand how you could think you're going to enforce the judgment if there's no nationality.
Yeah,
so
that's
would
another.
that be like the key factor, and maybe they just don't spend much time on it because it's either there or it's not.
Yeah, enforcement is another problem. I mean, if they realize that they cannot enforce it, probably the parties will not bring the case to court.
You would expect, I mean, but enforcement could be based on other types of assets in the US, right? So that could be this mix of situations which you had about maybe the firm is located in the US, has some assets, but the nationality of the owner of the firm is Indian or German or whatever.
Or you enforce it by blocking access of the products at the border or something.
Yeah, ITCs. Yeah.
And then, just to complete that picture, that is the picture for the Timberlane test, the multi-factor test. And if you look at that, there's another interesting correlation. The effects test is the blue one, and in that period of the high watermark of Lanham Act application in the Ninth Circuit, you see that the effects test is much stronger, occupies much more space in the court's decisions than the committee test, which is the red. And then when it started going down the Lanham Act application rate in the Ninth Circuit, you see that the committee factor was more important for the judges. That somehow correlates. And I have more qualitative data on that. Factor neglect, that means the courts did not even discuss the factor, sometimes did not even mention the necessity to test that factor. You find that in more than 40% of all decisions, the court may have mentioned that nationality is one of the three factors, but they did not apply the law to the facts. They only analyzed effects and left nationality undiscussed. In almost 50%, they did not discuss conflicts, and in only 14%, I have to say only, because evidently that is the more important factor. They hardly missed a discussion of effects.
Can I ask on this conflicts issue? I remember from what you mentioned in the first Steele, the original case. So conflicts is essentially only a question of whether the defendant owns a right in that name in a foreign country.
Yeah, there's more intra-factor specifics. So there can be conflicts if there is a valid registration or an application somewhere. The courts in the Fifth Circuit, the American Rights Courts, they say, well, first of all, we need a foreign court judgment to say that the defendant has a right to use that trademark. So that's the highest option. Yeah. And then all courts say, virtually all say, the burden of proof for that conflict is on the defendant. Okay. That makes it more complicated. And then there's very liberal courts who say, we look at the actual policy of the foreign country. Yeah. So there was one conflict between an Italian and an Indian party on a copy of, I think, a Vespa bicycle, motorcycle. And then they said, well, we have to look at the policy of India to engage production of that kind of vehicles. And so they said, well, that could be a conflict already if we disallow production under a certain
So that's kind of like
it varies. I mean, that is all over the place.
That's comedy, essentially.
Yeah, it's comedy, exactly.
So, sorry, I'm just being thick, but you're saying that you just look and you see how much time in each case, how many words in each case are taken up with each of those factors. But I still don't see, for example, why nationality could have very few words taken up, because most of the cases that come there to the courts, the nationality issue is very clear. Yeah. So the courts only have to say something very little about it before they get to conflicts, which is much more complicated.
Yeah. That's what I think is surprising, because still, I mean, they even at that time here, they were discussing more about nationality than, I mean, only slightly more. Mm-hmm. But conflicts has been treated very, very, very badly, to say, all over that. Which, as you say, is the committee aspect.
And it may also, I mean, if the burden is on the defendant, right? And if you actually have this very high threshold, if the defendant knows he has to produce, a court decision.
Exactly.
Well, I mean, for example, it seems that the defendant simply saying that I have unregistered rights, protection under passing off, right?
Yeah.
That in itself apparently wouldn't convince the U.S. court, right?
Exactly, not any. Yeah.
Would expert evidence then suffice? Getting someone like Lana writes, he's been using this here and so on, and would that suffice?
That would suffice. There is one case that was a male ballet troupe in Japan, and the largest market was Japan, and then the competitor, they only slightly renamed their troupe. I mean, there was a very similar name, and they stole their trade in Japan, and then by version of sales in Japan. And then they heard an expert. That was one of the decisions where they heard an expert on Japanese trademark and anti-competition.
Okay.
Yeah. So that would probably be enough, but still it's a huge obstacle if you have to prove that. And then that would not suffice. That was the case in the Second Circuit. It would not suffice in the Fifth Circuit, because there you need a court decision.
But indirectly within that conflict analysis, you sometimes seem to get situations where US courts do at least take into account factually of the situation in a foreign country, right?
Yeah.
And look at that law.
Yeah.
They probably don't apply it themselves, right?
Yeah.
But they invite a foreign expert,
Exactly.
or ideally a court decision or something
Yeah.
of that sort.
Yeah.
Okay.
One more qualitative aspect, if you look in more detail at the interaction of the factors in the three-pronged tests, not the Timberlane test, you see that when there was no effect, when there was a negative finding on effect, they would never apply American law. So effects is actually the driving factor when it's not existing. And if you find effects, they still applied American law in 96%. They only did not apply American law when both nationality and conflicts were pointing against American law. That is not very unexpected that effects is the most important aspect, but still it's interesting to see that whereas effects is more expressly named the most important aspect in antitrust, for instance, it's here as well, even though you have other factors. And then there is more statistical testing for that. I don't want to go into much detail. Correlation and regression analysis somehow reflects and verifies those findings. The larger the correlation factor, or the closer it is towards 1 or -1, the stronger the correlation, the closer it is towards 0. And you see the 0, the smaller it is. And you see here the effects correlation coefficient is much larger, it's 0.8 compared to conflicts and nationality. And the regression analysis also shows that the odds ratio for effects is 42, while it is 10 for nationality and 5 for conflict. Correlation and regression kind of explain the statistical association between those different factors. You can also show correlation for the Timberlane, the committee test, the large test, and there it's interesting to see that committee is even stronger than effects. You can't do a regression analysis on the data here because that does not deliver reasonable results. As I mentioned before, I found one more thing, that is a bad faith factor. It's rarely expressly mentioned by the courts, but most of the courts mention it somewhere that there was bad faith, but they never mention that they would apply American law due to the fact that there was bad faith. So you have overall almost 60% of all disputes involved bad faith on side of the infringer, piracy, counterfeiting, some other constellation. And the Lanham Act application rate was more than 80%. So that's good to know for a lawyer if you have a client and then just counsel that it would be good to emphasize the bad faith of the defendant. That might be a good argument. Correlation coefficients are also showing a correlation. So in the three-pronged tests, the Vanity Fair and all those other three-pronged tests, you could say the effect factor dominates. In the rule of reason, in the Ninth Circuit, the Timberlane, it's more committee, you would say, but effect factor as well. And then you have the bad faith of the defendant that implies application of the Lanham Act in most cases. And that's the last part of the analysis, the intra-factor analysis. I want to focus on the effects factor, where you can find, and I'm going to explain what that means, a transnational goodwill extension paradigm. That means those cases show a certain pattern of extending the goodwill across national borders. Where did it start? The starting point is the so-called T. Rose Rectanus doctrine, which was an inner American doctrine, so within the United States, two Supreme Court decisions, 1916, 1918. The issue was an extension of common law trademark rights across state borders within the US. And the concept was very simplified, a marketplace trademark rights correlation. Wherever the trade goes, the trademark right goes. Just again to mention it, it was within the United States. The Hanover Star decision of the Supreme Court, which is one part of the doctrine, said, we agree with the court below that since it's the trade and not the mark that is to be protected, a trademark, and now it comes, acknowledges no territorial boundaries of municipalities or states or nations, but extends to every market where the trader's goods have become known and identified by his use of the mark. What has Steele done? It has globalized that doctrine. First of all, Steele expressly said, we're going to apply the former common law, even if we now have, or even though we now have the Lanham Act. We see no reason why we should restrict the jurisdiction of the Lanham Act. And inter alia, they referred to the fact that those watches could well reflect adversely on Boulevard's trade reputation here as well as abroad. They mentioned that trade reputation was to be protected in the US and abroad. The concept was a common law goodwill extension which was non-territorial, non-political. Let me explain that on the basis of the progeny. And those are just a few examples. There's plenty of that. So one decision from the Southern District of California, the court there said the Lanham Act imposes upon this court a duty to protect the entire gamut of purchasers, including non-English speaking purchasers in various countries throughout the world. And the policy was to prevent unfair trade practices even in foreign commerce. So it's a very wide interpretation of the Lanham Act's protection purposes.
It does seem to suggest that the importance is you're protecting the purchasers rather than the goodwill.
Yeah. But the policy, I come to the sub-factors of effect, which is confusion prevention. So that is consumer confusion. You look at consumer confusion abroad. The next example is Reebok, which refers to the American Rice paradigm, which said, well, the sales of counterfeit Reebok shoes decreased the sale of genuine Reebok shoes in Mexico and in the United States. And that is an injury that is accepted as producing effects under the Lanham Act. So decrease of sales in Mexico and in the United States.
Okay, so if we go back to Steele and Boulevard,
Yeah.
were Boulevard selling already in Mexico?
No, not yet. But they were advertising in Mexico, heavily advertising, that's what the court said. They were building up a goodwill in Mexico. It's complicated to say that goodwill already exists with advertising.
Yeah.
It's a bit of a complicated issue. I couldn't find a real solution out of the Steele arguments or the reasoning there, which would probably, the literature would have said that is not enough.
But they managed to get the trademark initially owned by Steele off the register. Was
Exactly.
it based on Article 6 bis?
That would be interesting to know. I don't know. The courts did not tell us. That would be interesting to see. Yeah. Or maybe Mexican law said, well, there is goodwill in or passing off or whatever in Mexico.
When was Article 6 based on it in the Paris Convention? 1928?
The decision was 1952. Maybe.
And we were just wondering at what time Article 6 bis, probably in its current format, actually came into force. I don't know.
I checked
There was
that.
something happening in Lisbon in 58
Yeah.
that the Australians opposed.
This was quinquis, 6 quinquis
Was that
on,
something?
Yeah.
on what is it? As is protection.
Telltale.
Yeah.
Yeah.
Well, it was the 1920s, so, but was Mexico a member then?
Yeah, I don't know whether they were.
They were a member.
They sign up to it.
Yeah. Then one more example. I promise you there's more examples, and I showed the complete data. That was from the Third Circuit and they directly referred to Hanover Star in an international conflict. They said, well, the trademark is protected only in geographic areas where it has established a market, or where the owner has established a market. And then they cite to Hanover Star, they say, well, a trademark acknowledges no territorial boundaries and so on, but extends to every market. And they concluded for the decision that it is in this context that the district court, that was the appellate court here, concluded that Enterprise, that was the trademark owner, had demonstrated no presence in locations other than the United States and Monte Carlo. That was the reason why they said there is no protection in Russia and Australia, as I remember. But if I'm not misinformed, Monte Carlo is not a state of the United States. And they still said, well, there is protection. And Monte Carlo is not even a common law jurisdiction. So that's kind of that what I explain as a transnational goodwill extension. Let me clarify that with a bit of graphics. If you have a marketplace in one state of the United States, you have a common law trademark right without registration. If you extend the marketplace across the border to another state, let's say from New Jersey to New York, you also have a common law trademark right in New York. And now the concept that seems to underlie those cases is that if you extend it across the border to another country, where we would probably say, well, then we apply whatever happens here, we apply the law of that foreign country. They would probably also say there is a common law trademark right. We protect that goodwill at least.
So in that intra-US expansion, you have New York, New Jersey, or whatever.
Yeah.
So in that scenario, would the common law doctrines vary between different states? And if so, would the expanded part be on the basis of the application protectiones? Like, would they apply the law of the state to which you expand, or would you kind of like expand the original common law as from the country or state of origin?
That's my understanding, is that you would expand that you would not differentiate.
Okay.
I mean, you would probably assume that the common law is the same everywhere.
Oh yeah, I guess.
I couldn't find any, I mean, I've been to the history a bit of that T. Rose Rectanus doctrine, and there has been some discussion when the court said, well, that there is no federal common law anymore, that each federal court has to apply the state common law. And there was some discussion of whether that might produce a checkerboard of different common law trademark jurisdictions. And there the courts, interestingly, and the discussion was that, or you could see that the courts would still continue to apply the old precedents, and that there would be a common law in disguise, a federal common law in disguise somehow.
So are we saying that, because you said the boulevard was advertising in Mexico,
Yeah.
so are you actually saying that there does need to be, although the effects, you measure the effects on the company in the States, because that's where, so does it mean that there must be a presence in the foreign country of some sort, which gives them goodwill in that country? I mean, do the courts always assume that?
Yeah. Well, it depends. Some courts said if there were sales abroad and there was a loss of sales, you would find a damage to the goodwill there, or damage to the business.
Yeah.
They did not really differentiate that. And then you would say if there was consumer confusion, which assumes that there have been sales before or something, and as
generally there has to have been some kind of goodwill built up by the American company in the
and there may be less. You may need less than, for instance, you may not need many sales abroad.
Mm-hmm.
Maybe advertising would be enough already. Could be, but if you look at the factors again, those are the effects. Some of the effects are factors. So that means courts would say we find effects if we have consumer confusion in the U.S., or we find effects if we have a diversion of sales in the U.S. So if the infringer's activities lead to a loss of sales of the right owner, or we find effects if we have damage to the goodwill, like in the Steele case, when you have counterfeited watches filtering in and giving the impression that Bulova watches are qualitatively inferior. Then you have effects if there is a misrepresentation, and you have effects if there is a misappropriation or tarnishing of trademark goodwill somewhere. And if you look at the cases, whether they accept as subfactors the occurrence of that situation abroad, so confusing foreign consumers, or diverting sales abroad, like in the American rice case, you have the following data, and I was very careful categorizing those cases. So I only took those cases that expressly said they would give regard to whether something happened abroad. You have more than 50% of cases where you find one of these constellations, and in more than 75% of all cases they applied the L.L.M Act. That again is the circuit. You see in the Fifth Circuit their rate is extremely high, 69%, and then it's more in the Ninth Circuit, but also in the Second. The red is the transnational goodwill paradigm. Just one last conclusion on efficiency. I want to go back to the procedural aspect we spoke about, that which parties you get into a US court. If you substitute or if you agree that the risk of litigation or actual litigation is costly, you would say within a market you have the higher burden on the domestic parties that are competing abroad or in an international market, because they have to comply with both American law and foreign law. And then if you formally play that game, you would say sooner or later competitors with more costs will exit the market. That is an extreme model, and you would probably not say that all domestic exporters will exit foreign markets due to the fact that they get the risk of being submitted to US law, while the foreign competitors are not. But it's an anti-competitive problem here. You have a problem with competition fairness. It's a discrimination against national competitors, actually, what American law does. So some conclusions. I would say, who am I to suggest a reconceptualization of American law? That's what Americans have to do. I'm just a German lawyer looking at that. But I would not go so far to suggest any big changes, because even though it's sometimes said that the common law would run into a dead-end street, you can't see that really here, because if you look at the case, the picture of cases and how they use their precedents, how all those ideas are kind of flowing back and forth through the circuits, there is no dead-end tendency, because that looks to me much more like a homogeneous picture of jurisdictional ideas that get exchanged and transplanted between the circuits. Is there a circuit split? Well, looking at the numbers with respect to the outcome, it seems that there rather is something moving toward the average, toward the mean. Could continue to look different in the next 10 years, but it doesn't look like the Ninth Circuit has developed into something of a right owner's haven. Does not seem to be. What could you do to moderately modify it? One problem seems to be the nationality factor. If you say, well, we don't look at nationality anymore and we just look at effects, you would at least kind of get rid of the problem that there is a discrimination of national parties. That could be one aspect where you could modify the law a little bit. And then, with respect to that transnational goodwill aspect, you could say if we repoliticize or politicize effects testing, that means if we just look at effects on the territorial ground and not abroad, we could cut back the reach of American law a little bit. After all, that's a political question. If you apply American law to facts or scenarios that occur on foreign territory, what is the foreign state supposed to say? How will they react? So there can be both a political friction and an economic downside of that. And then finally, I have not mentioned many of the data here. Conflicts testing is still something that is treated stepmotherly, as we have seen. There could be more to it to fine-tune the application of American law on those cases. That would require more policy and committee testing. Thank you very much.